You are walking through a parking garage at night and you nearly eat concrete because some genius decided lighting was optional past sundown. That stumble is not just clumsy feet, it is actually the beginning of a legal case that most people never think to build. Poor lighting and missing signs feel like small annoyances, like a restaurant forgetting your extra napkins, but in accident law, they are treated like silent characters who caused the whole disaster and then snuck out the back door. Here's the weird part most folks miss. A crash does not need a drunk driver or a texting teenager to be someone's fault. Sometimes the property owner or city just failed to do their homework. Think about a four-way intersection where the stop sign is hidden behind an overgrown tree. Nobody in that scenario is a mustache-twirling villain, but negligence does not require a villain, it just requires someone dropping the ball. Lawyers call this premises liability or municipal negligence depending on who owns the space. Basically, it means whoever controls that road, lot, or building had a job to keep it reasonably safe, and reasonably safe includes visibility. So how do you actually prove the darkness or the missing sign caused the wreck? You cannot just say it felt dark, you need receipts. And receipts in this world look like maintenance logs, city inspection records, and photos taken immediately after the crash. Timing matters more than people realize. If a streetlight has been reported broken for 3 weeks and nobody fixed it, that paper trail turns a random accident into a pattern of ignored warnings. Enter the accident reconstruction expert, basically a detective with a protractor. They measure sightlines, calculate how far headlights actually reach, and figure out whether a driver could have realistically seen a hazard in time to stop. Witness statements help too, especially from people who live nearby and have complained before. One angry neighbor emailing the city about a busted light for months is basically a walking, talking piece of evidence. Cameras are the unsung heroes here. Traffic cameras, nearby business security footage, even a doorbell camera can capture lighting conditions exactly as they were, which beats human memory every single time. Signage cases work almost the same way. If a stop sign was knocked down, faded past readability, or blocked by branches, that is a maintenance failure. And maintenance failures are exactly what insurance companies dread proving in court. Here is where people get confused. They think proving fault means proving someone meant to cause harm, but negligence law mostly cares about carelessness, not intention. You also need to show the crash would not have happened or would have been less severe if the lighting or signage had been proper. This is called causation, and it is basically the bridge connecting "they messed up" to "and that is why I got hurt." Preparation is everything in these cases, almost like packing an umbrella before a forecast that only sort of promises rain. The more documentation you gather early, city complaints, photos, expert opinions, the stronger your position becomes before memories fade and evidence disappears. If any of this sounds like something you or someone you know is dealing with, you do not have to untangle it alone. Want to learn more about how we can help? Check out our links in the description.